judgment is dated 15th of February 2024.
Yes, ma'am.
We are now on the 11th of March.
Yes, ma'am.
In the last 26 days, what extent of matching has been done by you? What steps have you taken in the last 26 days? The application is absolutely silent on that.
We can put a detailed affidavit on that one,
No, we
because
don't
I
want
know.
By a judgment dated 15 February 2024, this court declared the electoral bond scheme and the provisions of the Finance Act 2017, which amended the provisions of the Representation of the People Act 1951 and the Income Tax Act 1961 unconstitutional on the ground that the non-disclosure of information regarding the funding of political parties is violative of the right to information of citizens under Article 19, bracket 1, bracket A of the Constitution. Full stop. The amendments which were introduced by the Finance Act 2017 to the provisions of the Companies Act 2013, permitting unlimited funding of political parties by corporate entities, were held to be arbitrary and violative of Article 14 of the Constitution. Full stop. Next para. In order to give full effect to the judgment which was rendered by the Constitution Bench, this court directed the State Bank of India, footnote SBI, which was the authorized bank to deal with electoral bonds under the electoral bond scheme, to submit details of the electoral bonds purchased by the contributors and redeemed by political parties between 12 April 2019, into brackets, the date on which an interim order was passed by this court directing the Election Commission of India, footnote ECI, to collect details of the contributions, bracket, till 15 February 2024, bracket, the date of the judgment. Full stop. This court directed SBI to submit the following details by 6 March 2024 to the ECI. A. details of each electoral bond purchased, including the date of purchase, the name of the purchaser, and the denomination of the electoral bond, semicolon, and B, details of each electoral bond redeemed by political parties, including the date of encashment and the denomination of the electoral bond. Stop. The ECI was directed to collate the information which was submitted by the SBI and publish it on its website by 13 March 2024. Stop. SBI filed a miscellaneous application before this court 2 days before the expiry of the deadline, seeking an extension of time until 30 June 2024 for complying with the directions. Full stop. The petitioners before this court, Association for Democratic Reforms, and the Communist Party of India, Marxist, instituted contempt proceedings, instituted a petition invoking the contempt jurisdiction of this court against SBI for an alleged willful disobedience of the order of this court. Full stop. In support of the application by SBI, I've heard Mr. Harish N. Salve, learned senior counsel. Full stop. Mr. Salve submitted that the information which was which was received by the SBI was maintained in two separate silos and were maintained with the utmost secrecy so as to fulfill the core purpose of the electoral bond scheme. Full stop. Learned counsel submitted that if the disclosure is to be made of the information required to be submitted by SBI to ECI in the separate silos which are referred to in B and C of the operative directions, there would be no difficulty in SBI doing so, which, it has been indicated, would be completed within 3 weeks. However, it has been submitted that the difficulty of SBI arose since it construed the directions of this court in requiring it to carry out a matching exercise to match the donor details, the donor and bond details with the corresponding details pertaining to encashment by political parties. Full stop. While evaluating the submission which has been made on behalf of SBI, a reference to some of the key aspects of the scheme would be in order at this stage. Full stop. Clause 7(4) of the electoral bond scheme stipulates that the information furnished by the buyer of an electoral bond shall be treated as confidential by the authorized bank and shall be disclosed only when called upon to do so by a competent court or upon the registration of an offence by a law enforcement agency. Full stop. Thus, in terms of the provisions of the electoral bond scheme itself, SBI is mandated to disclose information when demanded by a court. Full stop. What remains to be seen, what has to be analyzed
I have full details of who purchased the bond, but that's put in one silo of information. I have full details of where the money came from, which is in a second silo. And I have a complete detail of which political party tendered how many bonds and who has been paid how much. That's a easy ask. That can be given straight away. The problem is, Manoj, I have to now put the name of the purchaser, which is in the first sealed packet, and these are all physically kept. They were not put into the banking system. And each form will have to be taken out, the name checked, that name now correlated to the payment detail, and the payment detail correlated to the bond, and finally that's where the bond number gets generated, and then we can connect as to which political party who has given that money. SBI shall submit details of electoral bonds purchased since the interim order of the court. Well, no problem. No problem. The details shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchase. Now, my lord, when the purchases were happening, we divided the information. The name is kept at one place and the purchase is recorded at another place.
But ultimately, everything was sent to the Mumbai Central Main Branch. All issuing branches for the political parties, there are only 24. Actually, there are 4. But insofar as the purchasers are concerned, everything has been remitted back to the Mumbai Central Main Branch.
Except, I'm sorry, Manoj, your lordship.